What I'm going to talk to you about for the remainder of the time that I have with you is what is competent lawyering in the 21st century. And I'm going to start by telling a little bit of a story, because after all, I'm a law professor, so you'll have to forgive my idiosyncrasies. And the story is about the history of legal education. So the story begins this way. As if you didn't think I was a geek enough wearing this and playing Star Wars music. So what happened a long time ago at a law school not very far away? The development of the case method of legal education. And most of you probably have a sense of what this involves. It means reading a lot of cases and being able to extract from the cases basic legal propositions and being able to apply those legal propositions to new areas, new factual contexts. It's one of the core features of legal education, and we law professors do it pretty well. And so this was developed at Harvard Law School, and so you may wonder, in the more than 100 years since this innovation of the case method, what does legal education look like today? Legal education in the present, well, it looks pretty much the same at many law schools today as it did decades ago or even a century ago. To be sure, there have been some innovations. So, for example, there are new doctrinal courses such as international law and a wide range of other subjects. And there's a greater emphasis on practical skills, clinical education, as well as legal writing. But for the most part, law school has not kept pace with the dramatic changes taking place in the legal profession. And you all are on the front lines of seeing how these changes are occurring. This is just a snapshot of the new reality, but I think I'm preaching to the choir in this regard. Obviously, electronic discovery has changed the way that litigation is done. There's automated document assembly, virtual law offices, cloud computing, different methods of delivering legal services through project management, LPO, social media. The world is completely different. So you may wonder, what can law schools do to respond? And so forgive the little bit of marketing here about the Institute at Suffolk, but I want to give you a flavor for some of the things that are taking place at Suffolk. And there are a few other law schools that are doing the same, but in my view, not as many as there should be. So we're offering new courses. So a great new course is project management for lawyers. Project management is increasingly important, not only in the business world, but obviously in the delivery of legal services as well. We want our students to have some sense of project management. We want them to understand that being a Six Sigma black belt doesn't mean that you're an expert at Taekwondo. That there is something important that they need to understand about how legal services can be made more effective and efficient. Lawyering in an age of smart machines, an automated document assembly course. I know Tejas was in that course and learned how to automate various procedures. 21st century legal profession, basically introducing students to all of the new innovations in the legal marketplace. Electronic discovery, of course. And we're developing externships with non-traditional companies and employers. So usually, students would go out and do an internship with a government agency or a law firm. Our view is that's a very limited universe of what the legal profession looks like today, and that we are encouraging our students in developing relationships with companies like Evidocs, where we can get our students working in an e-discovery company or for an automated document assembly company, working for an LPO, getting a sense of the way in which legal services are now being delivered. And there are a bunch of other new courses as well. I'll just give you a sampling of other projects because I think you might find them interesting. We developed a new litigation app to make a variety of legal resources more easily available to lawyers when they're on the go. Obviously, there's Google Glass, this new concentration in legal technology and innovation, which is basically a law school major to help students who really want to focus in this area, give them the courses that they need and the background that they need. And then there's the Suffolk Flaherty Legal Tech Audit, which is really what I'm going to spend the rest of my time talking about in just as soon as I'm done with this piece in just a second. But the overall goal is about providing students with the knowledge and skill set they need to be a competent legal professional in the 21st century, so that we can move away from the model of just the case method and thinking that that's enough for our students to understand. The world looks much different from when that was created. And I think this is an ethical obligation. So I had the privilege of serving as the chief reporter for the ABA's Commission on Ethics 2020, which was responsible for this change to a comment buried in Rule 1.1, which is about the duty of competence. But this particular change, even though it was buried in a comment, seems to have gotten a lot of attention. And what we found in the commission is that if you look at the rules of professional conduct, or you looked at them before we made any changes, what you found is that there was not a single reference to technology anywhere in the rules of professional conduct. I don't think that that's appropriate in this day and age, and the commission ultimately decided that what we need to do is define a competent legal professional today in terms of technology, that you need to stay abreast not only of changes in the law and its practice, but that necessarily includes understanding the benefits and risks associated with relevant technology. So let me talk to you about two aspects of competence in a digital age, and I'm going to focus primarily on the competent use of law practice technology. And I'm going to do that by talking about Casey Flaherty, who's a corporate counsel at Kia Motors America. And what he found was that when he was dealing with his outside lawyers, they were not particularly good at using technology. And I don't mean Google Glass. I mean Microsoft Word and Outlook and Excel and Adobe. They just didn't do it very well. So they might be able to create a document, but they weren't doing it very efficiently. And so what he decided to do was test them. It seems not an unreasonable idea if he's using these outside lawyers to see if they know how to use the basic law practice technology efficiently, since they're billing his company for their time. So he went out to their offices and developed a legal technology audit. And he asked the lawyers to perform certain basic tasks. And what he found, as this slide suggests, is that tasks that should have taken no longer than an hour on average took 5 for these lawyers to complete. It's a sad commentary, and I think, unfortunately, there are a lot of people who go into law because they're afraid of numbers. It drives me crazy when I hear that. They're afraid of technology. That's why they went into law. I don't think that is a good response. I bristle when I hear it from my days of programming my Commodore 64 up to the present. I don't think that's a good response for lawyers, and Casey Flaherty agreed, and to develop this audit. So let me give you a flavor for what drove him crazy and why he decided to create this audit. So here is an example of somebody using Word inefficiently. So imagine the lawyer who is crafting a document for Kia, some kind of agreement, needed to add a new paragraph. And imagine that the approach the lawyer takes is as follows. So you hit return a couple of times, you add the text, you add a Roman numeral 2, you highlight the text, you bold the text, you capitalize the text, right? You're getting the picture. It's very cumbersome. You create the right font, you right size of the font. It's painful. Then you have to change the numbers for the other portions of the agreement, which this person is doing manually, right? Because you've added a new provision. So everything else after it needs to change. And then, of course, the cross-references need to change. So cross-references to other paragraphs now need to be updated. And in this example, somebody's doing that manually. And so one step at a time, the person eventually gets to the end after this long and painful process. Now, this is just one small example. And of course, what should this have looked like? Here is the efficient way of doing it, and I think I'm probably not telling most of you anything new. You plug in the text, you go into the styles for the outlining. You can easily create the font and size in advance because it's part of the styles. And then in order to update the cross-references, you can go into the update field and get exactly everything that you need in a very couple of short steps. So what does this example illustrate? Take this and multiply it by dozens of activities that lawyers do on a daily basis. Who ends up paying the price for that? Well, the reality is that for the most part, at least under the billable hour system, clients end up paying for it. And so the question is, what are we doing with Casey Flaherty? What we're doing is taking the audit and we're automating it. So Casey went out to individual lawyers' offices and looked over their shoulders with a stopwatch, which is kind of ironic, given that it's a little bit of an analog way of doing some testing. We're going to make it available online. We're going to enhance it with new tasks, and we're going to administer it for the legal profession to use. And the goal is really to incentivize lawyers to use technology as effectively and as efficiently as possible. Many of you might ask, why haven't lawyers figured out how to do this already? Why aren't they doing this already? Part of it is the fear of technology, but that's not a very good answer. I do think that what it does boil down to is the billable hour. For the most part, the billable hour does not reward efficiency. In fact, it doesn't reward efficiency at all. The more time you spend on a matter, generally, the more you make. And so why would you enter the contract provisions any more efficiently than you're already doing it? There's no great incentive to do it. Clients are finally pushing back. There's been a movement away from the billable hour towards alternative fee arrangements, and I think that's driving a lot of the push towards law firms and lawyers taking this a lot more seriously. So we hope to be a part of training the next generation of law students and lawyers so that they are able to use these basic law practice tools more effectively. So some of you, and I know from talking with other groups, may object to this idea of a legal technology audit and say, you know, that's just stuff that can be delegated to staff. And Casey has heard this as well. Why are you testing our lawyers on something like Microsoft Word? In the example that I just showed you, we all know that that just goes to staff who will add the necessary text. And I think there are a number of responses. First of all, law firms are getting leaner and meaner. There are just fewer staff to go around. There just is not as much administrative support as there used to be. Second, oftentimes with that example, when you can do it in a minute, why would you go and seek out somebody and explain what you need to have done? It actually could be more time-consuming to delegate it than to do it yourself. And then somebody may not do it the way that you need it to be done. And the rules of professional conduct impose on you an ethical obligation, a duty to supervise non-lawyers. So you not only have to ensure that it's done right, you have an ethical obligation to make sure that it's done right. And then you have lost time. So once you give the document over to somebody, that's time that you can't be working on the document. And then you could have version control problems. So whenever you turn something over, it has these costs. And then many times the need can arise after hours when there is no staff available. And so lawyers end up doing this kind of work themselves. And then Casey's final point, which I think is persuasive, if staff at a particular law firm really are doing this themselves, test the staff. At many law firms, they're billing for that time. So make sure that the staff know what they're doing and know how to do it as efficiently as possible. So a few other questions that people often ask about this legal technology audit. Who's going to be able to participate? So we're going to make it available to corporate counsel, so in-house counsel who want to test the ability of their outside counsel. And they'll be able to use it for free. And so we're just trying to make, it's kind of a public service. We're not trying to monetize this. I'm not here to proselytize or make money off of this. We really think that it's a service to the legal profession and most importantly to clients. And so that's what we hope to achieve. Some people say, well, won't lawyers cheat? You could imagine this scenario. One lawyer in a law firm is taking the audit, and then that person who's going to take it in the afternoon is looking over the lawyer's shoulder, or a word gets out about what's on the test, so to speak. Our reaction to that is great. If that means that lawyers are finally taking this seriously enough that they want to learn how to use Word, mission accomplished. Good. Let them figure it out, and then let them pass the test, and then we'll come up with new things to test. And that's the other part of this, is we're going to be adding additional modules over time. And one module we want to add, and I'd be very interested to hear your feedback on this piece of it, is an Ediscovery module. What should we be testing lawyers about in terms of Ediscovery? What kind of knowledge should they have? What kinds of skills should they have? I think this is a little bit more difficult to incorporate in an audit, but I think it is possible, and I would certainly value your feedback. Another area that we want to add eventually is cybersecurity, is making sure that lawyers have the basic understanding of how to protect the information that they're holding for their clients. So coming back to the two examples that I wanted to use of the changing nature of competence, I want to end with a discussion of the duty of confidentiality. And I think this impacts not only lawyers, but e-discovery companies that are increasingly handling a large volume of information. And it directly bears on e-discovery because lawyers, when they are outsourcing to an e-discovery company, are necessarily having some duty of supervision regarding how that information is maintained. So let's do another kind of story and history lesson. You don't have to go too far back in time. You can go back to when I graduated from law school 17 years ago. And I think about how information was stored and protected when I graduated. That is, how were client confidences kept from prying eyes? It wasn't that hard. You had a file cabinet, and it had a lock, and you closed your office door, and you locked it. Done. I've satisfied my duty of confidentiality. The reality is, it's much more difficult to do that today. The reason that this conference is happening is because information is stored in so many different places that it can be much more difficult to secure. And so the question, a basic question that lawyers are asking themselves, is what do they need to do today when they're carrying around information on their smartphones that's confidential, when they may be wearing their client's confidences on their face, which is around the corner. What do they need to do to protect that information? And what do lawyers need to do to protect information that they may be getting from their clients and having an outside company, in e-discovery, for example, process? The answer was very unclear under the rules of professional conduct until recently. Rule 1.6, which is the duty of confidentiality, really didn't speak to this problem at all, largely because it didn't have to until recently. So another piece of the work of the Ethics 2020 Commission was to add new content to Rule 1.6 to make clear that a lawyer's ethical obligation includes taking reasonable precautions to protect client confidences from inadvertent or unauthorized disclosure, and then identifying some of the factors that lawyers need to take into account in terms of whether they have complied with this ethical duty. And you can see the list of factors, and they're in the rules. And for those of you who are licensed here in Massachusetts, the Massachusetts rules, there's a proposal to change them as well to mirror exactly what the recent model rules changes accomplished. Now, I don't mean to make everyone paranoid that if somehow the information gets out that you're all going to be subject to discipline. That's not the intent of the rule change. The idea is reasonable precautions. Nobody's expecting lawyers to have the security that you might find at the Pentagon. The idea, or maybe it should be better, in any event, the idea is it's reasonable, is the touchstone. And then there are obviously a lot of other aspects to this. Lawyers are increasingly going to the cloud, and there are a number of new ethics opinions dealing with basically a lawyer's duty of competence when dealing with the cloud and duty of confidentiality. The bottom line here is that ethics opinions generally conclude that you can use the cloud with a proviso, an interesting one here in Massachusetts, that if you're storing particularly sensitive information in the cloud, you get client consent. That could have potential implications depending, in the e-discovery context, depending on how information is stored, how it's being sent, and transferred back and forth. So it's another important point to keep in mind. And so a few other tips and important considerations about the cloud. I think with this audience, I'm probably not telling you much that's new, but the importance of encryption, knowing who has access to the information, who owns it, is an increasingly important question. The use of strong passwords and multiple factor authentication. So lawyers are frequently still left in the dark about exactly what they should do. And the ABA is in the process of creating a website that will answer, it'll be basically legal technology for dummies with answers to very basic questions. So what is a strong password, how many characters it should be, and different types of characters and that sort of thing. And then encryption. This goes back to lawyers not being well versed in technology. When I give presentations, here are the 3 questions that I ask. I ask, first of all, well, actually, it's 4 questions. How many of you carry around client confidences on a mobile device, either a laptop, a cell phone, a flash drive? Really? Come on. You do. I do. So sensitive information is stored on mobile devices. So how many of you encrypt your mobile devices? How many of you don't encrypt your mobile devices? And my favorite question is, how many of you still have no idea what encryption is? And I always have a few brave souls who raise their hands, lawyers who have been practicing for a long time and don't really have a clue. They think, well, my laptop is password protected. And so therefore, that's encrypted, right? People who they don't know my password, they can't get access to my information. Well, if somebody steals your laptop, they can pop out that hard drive and read everything that's on it. People are often surprised to hear that you don't need the password to the computer in order to access the information, and that encryption means something else entirely. And so there's a serious education need that needs to take place regarding the protection of information, of electronic information today. So the bottom line here is that it's a brave new world for lawyers, that what it means to be competent today is very different from what it was 10 or 15 years ago. E-discovery is certainly one piece of that a competent litigator today needs to have a sound understanding of how to use electronic discovery, how to be efficient about it, how to be effective about it. But that's one small piece of a much bigger puzzle, I think, about how do we produce competent legal professionals for the 21st century. So with that note, I very much would like to hear your feedback and your questions. Thank you. Yes.
Teach civil procedure. Have you thought about, rather than teaching it separately from e-discovery, having a combined course?
Great idea about having e-discovery in a combined course with civil procedure. I'd love to find a way to do that. If anyone wants to work with me on creating such a component, all right, give me your card or text me. I'll take it on glass. Yes.
You talked about educating the next generation of lawyers. You thought about making any of this stuff accessible to current attorneys, maybe older ones who are looking for a way to move forward?
So about making information available to current attorneys, not just law students. So one of the things that we've thought about is creating a program for people who have already graduated from law school who really need this kind of training and want to learn more, whether it be a formal master's program, I don't know, or a certificate program, maybe somewhat more modest in scope. But I think the idea is that we recognize that there's a need in the marketplace and that many people might benefit from getting this kind of information and want to go back to school, but perhaps in not the formal way that they did once before. But yes, I think that's something that we have on our radar screen. Other questions? Yes. Yeah. Say again? Good question. So what you do is you have it Bluetooth connection to a cell phone, and then you can, using an app, a Google Glass app, you can screencast what is on glass, and so my phone is picking up through Bluetooth what's on glass, and then connecting the phone via a cable that converts it to an HDMI connection, and then the HDMI connection goes to the projector. How's that for an answer? There are many things that could have gone wrong. Yes?
My first computer was also a Commodore 64.
Commodore 64, nice.
And that is my comment. And my question is, actually, it's more of a comment, and I'm looking for a little bit of discussion from you. Talk a little bit about lawyers using smartphones. Maybe some law firms allow or encourage use of personal smartphones
Yeah.
to dial into their particular PC or save client confidences or perhaps talk to clients. If you could talk a little bit about that, I'd be interested in hearing your thoughts.
Yeah, so law firms or companies that allow lawyers to use their own smartphones, sort of the bring your own device movement, and what are the and clients as well using their own. So it raises innumerable issues. Whether it ultimately shouldn't be allowed, I'm not sure that I would say that. I actually think many of you in this room are in a better position to answer that question based on what you're seeing up close and personal with the kinds of issues that are coming up in the Ediscovery context, whether that is creating more issues and more problems than it's worth. So I guess my answer is going to be a very law professor answer. It kind of depends, and I don't have enough empirical information about how it's playing out at this point to know. But I think it's a great question to ask. I'd be curious if other people have a strong view one way or another about the BYOD movement and how that's playing out in the litigation front, and whether you view this as a problematic development, and what you would advise companies to do on that issue. So again, law professor move, you ask me a question, I ask a question back. Yeah. Anybody have a view on that? I'm actually curious as to the answer myself. What's that? It's towards encryption on the devices themselves. So that seems almost kind of a floor of something that any company should, if they're going to allow employees to use their own devices, I think that there should be a requirement that the information on those devices be encrypted. Yeah, I think that's a no-brainer. Absolutely. Beyond that, it's kind of hard for me to say. I'm, like I said, curious what people think.
Some companies are also making a move towards disclosure that if you're using a personal device for business purposes, you may have to turn it over for e-discovery purposes.
Yeah.
If you still choose to use it after you find that out, it's going to be your choice.
Yes.
But what comes as a shock to many employees is that if there are business records on a personal device, they still probably belong to your employer.
Yeah, so that's a good point about notice. So if you are going to go down the path of BYOD, not only encryption, but making sure that employees are aware that when they're bringing their phone into work and accessing their work email through it, that the entire device may be subject to discovery at some point. What's that? And remote wiping by the company? Good point.
I've heard of several different, firms, companies, clients, what have you, having different levels of policy. So, hey, we may wipe it, is one, and then all the way up to extremely strict, like we will wipe. This is exactly what we will do. So there's a lot of different variations.
Yeah, that is interesting. Other questions, observations, comments? Yes.
Custodial interviews in collecting data. I know a lot of clients have been really resistant, saying that their personal device, because they pay for it, is their personal device, where they do access company data. However, they are very resistant to turn it over.
Yeah. So the blurring of lines between what's personal and what belongs to the company is a really difficult one. And it's not only devices. One tricky ethics issue is when lawyers are communicating with clients through the client's email account at work. And that information isn't necessarily going to be privileged because the employer has access to that information. So it's really important for employees to understand that if they have their own counsel for any number of reasons, they better not be using their work email, and they better not be using a device that could be subject to wiping or access by the employer. So that's another important aspect of this problem. Other questions? All right. Well, I'll keep you on schedule. So thank you, Dana, and thank you all for paying attention. I appreciate it. Thanks for having me.